So therefore, the default committed by the debtor, in this case the corporate debtor, should not be less than 1 lakh. Central government can upgrade this amount which will not exceed 1 crore. Now then the question is, what is the default? Default means non-payment of liability, non-payment of obligation. Something which has become due, something which is payable by you, you don't pay, then this is the default. Now friends, so section 1, it extends to whole of India. Section 2, this applies to everybody. Resolution, solution, insolvency resolution, and then the liquidation, then the bankruptcy, and then section 4, it's about the corporate house, and the default is committed by the debtor. Now friends, let me talk about the definitions given in section 3. Probably that will help us. Definitions. What do you mean by claim? Number 1. Claim is the right to payment, right to remedy for the breach of contract, which gives you the right to payment. So this is a claim. Number 2, what is a corporate person? Corporate person is the company. Any company governed by the special act, any company incorporated under the special law, that's a corporate person. Who is the creditor? Creditor is the person to whom the money is owed. Yeah, debt is owed. O-W-E-D. IOU, debt is owed. He is the creditor. Number 4, what is the debt? That is the obligation. And the debt can be of 2 types, financial debt and the operational debt. Number 5, what is the financial debt? Financial debt means you borrow. You raise the amount by the issue of bonds. You have been given the credit facilities. That is the financial debt. What is the operational debt? Operational debt means you supply the goods and the services, and therefore the payment is due. That is the operational debt. You have been in the employment, and the remuneration has not been paid. That is the operational debt. So what do you understand by the claim? What do you understand by the creditor? What do you understand by the debtor? What do you understand by the financial debt? What do you understand by the operational debt? And then secured creditor. A creditor in whose favor the security interest has been created. What is the security interest? Security interest means right to interest or title created in the property in favor of the creditor. Right or interest created in favor of the secured creditor is the security interest. Then, what is the transfer? Transfer is a very wider word. Transfer means sale. Transfer means purchase. Transfer means exchange, mortgage, pledge, gift, loan. Any other form of right title is a transfer. What is the transaction? Transaction is a contract by which you transfer the fund and the assets. It's a transaction. What is the transfer of property? when you transfer the property or transfer the right in the property. So these words have been defined section 3. We have defined, and as I said, the definition, say 3 definitions, they cover the entire act, including part 2, with which you are concerned right at the moment. So what are the definition? Definition of the claim, definition of the creditor, definition of the corporate person, definition of the debtor, definition of the corporate debtor. Any debtor who is corporate. A corporate who is a debtor, he is a corporate debtor. And then default, and then transfer, then transaction, then the transfer of property, then the secured creditor, then the security interest. And the last definition, section 3, information statement, financial information. Financial information is a record of the debt. It's a record of the default. It is known as the financial information. So these are the definitions, section 3. Now we pass on section 5. As and when the discussion proceeds further, we'll take section 5. Now then, we start the process. What section 6 says? Debtor has committed the default. Then the insolvency resolution initiative to resolve the insolvency of debtor may initiate. You may initiate. Who may initiate? Debtor has committed the default. Corporate debtor, in this case, the corporate debtor has committed the default. Yes, you may take the step. You means either the financial creditor or the operational creditor. Operational, I have already said. Operational creditor or the financial creditor or corporate debtor himself can take the initiative. Section 6. Section 7. Section 7, 8, 9 or 10 talk about a particular scheme. What is that scheme? That the corporate debtor has committed the default. Then financial creditor can make an application to the adjudicating authority. Financial creditor can make an application to the adjudicating authority. What? Okay, please resolve this insolvency of this debtor, corporate debtor. He has committed the default, he is in difficulty, he is virtually in the insolvent position, unable to pay debts, he has committed the default, and I am making the application. Financial creditor is making the application to whom? To the adjudicating authority. And together with the application, he submits certain document that this is the kind of the default that he has committed. And financial creditor says, I propose the name of a person who will act as the interim insolvency resolution professional. If the adjudicating authority is satisfied that the application is complete, is perfect, the adjudicating authority may admit your application. May admit your application. So therefore, section 7, financial creditor makes an application that here is a default. I make an application for the resolution, insolvency resolution. Yes, and I propose the name of this person as the interim resolution professional. He will act here. And if the application is complete, then the adjudicating authority will admit your application. This is section 7. Section 8, you are the operational creditor. Operational creditor does not immediately make an application to the adjudicating authority. What the operational creditor does, you have committed the default. Who? Debtor. An operational creditor, as I said, operational debt means when the goods are supplied, services have been rendered, employment has been done, but the payment has not come. And therefore I become the creditor, you are the debtor, I am the operational creditor. And in a way we can say you are the operational debtor. So therefore the operational creditor under section 8 does not make an application to the adjudicating authority. Before making application, he gives you the notice, demand notice. And when the demand notice is given to the debtor, he can say, either he can say, I have already made the payment, this is my record of making the payment, or kindly check up your accounts, my payment has been encashed by you, or you are asking for the payment, I have raised the dispute. So I made a demand, I give a demand notice to you, I am the creditor, I am the operational creditor, and you are the operational debtor. You have committed default, I give the notice. In response to the notice, you give me the reply, I have already made the payment, you have received the payment, or I dispute your payment. This is section 8. Section 9. I make an application to the adjudicating authority. Okay, kindly solve the insolvency resolution. Now I make an application. What do I say in the application? I say, no payment has come to me. I am the creditor, operational creditor. No payment has come to me. He has not raised any dispute. And I may propose the name that he will act as the interim professional. If the adjudicating authority is satisfied that the application is complete, and the person whom I am proposed as the resolution professional, disciplinary proceedings are not pending against him, you may admit the application. No, friends. So section 7, financial creditor makes an application. Section 8, operational creditor gives the notice, demand notice. If you do not make the payment in 10 days, then he may make an application to the adjudicating authority giving all these documents. Section 9. Section 10. Even the corporate debtor can make an application. Corporate debtor can say, I am not in a position, I have defaulted, I make an application, kindly solve my problem. Resolution insolvency. He can make an application to the adjudicating authority giving all the accounts of him and the other information as may be required. So this is how the process starts. Section 7, 8, 9, 10. Section 8 is only demand notice. The application is made by under section 7, under section 9 and under section 10 for resolution insolvency. Section 7 by the financial creditor, section 9 by the operational creditor, and section 10 by the corporate debtor. Make an application. Application has gone to the adjudicating authority. You have made an application, and adjudicating authority has admitted. And once the adjudicating authority has admitted the application, that is the commencement of the insolvency resolution. Commencement. Once admitted, commencement. Once you made the application, it is the initiation of the insolvency resolution. So what is the initiation? When you make an application. What is the commencement? When the application is accepted. Now section 11 talks about the certain people cannot make an application. Who are these people who cannot make an application? Creditor, you want to make an application? Your application is already pending. Why you are making another? You cannot make. There was a completion of the insolvency resolution about a year before, and now you want to make application within 1 year, you cannot. So these are the people who cannot make an application. Your case is already pending, you cannot make further application. Your case was resolved 1 year before, you cannot make application. Section 11. Section 12. There is a time limit. Once you have made an application to the adjudicating authority, and you have recommended the name of the professional in your application, so the process will be completed within 180 days from the date of the commencement. When the adjudicating authority has accepted, it is the date of the commencement, within 180 days, it will be sorted out. In case it cannot be done in 180 days, correct, then the adjudicating authority may extend the time. On whose say, insolvency resolution professional can make an application if authorized by the creditors. If authorized by the creditors, by 3/4 of maturity, then he can make an application to the adjudicating authority, kindly extend the time. But the adjudicating authority is satisfied that yes, it cannot be completed in 180 days. They can extend the time for another 90 days. For any period, they can extend the time for any period not exceeding 90 days. And once you have given the extension, another extension will not be given. So time is very important. Previously, we used to take 3 or 4 years. Now today, 180 days. So section 11, some people cannot make an application. Section 12, the time limit. Who can extend the time? Adjudicating authority. On who's saying? Resolution professional. Why saying? Because authorized by the committee of creditors. By 3/4 of maturity, he can make an application. If you are satisfied, it cannot be done, you can extend the time for any period not exceeding 90 days. But once the extension is given, no further extension can be given for the same case. This is section 12. Section 13. Section 14, 15, 16. Let us omit section 13 for the time being. Section 14. Once the application is admitted, then moratorium will apply. Admitted by whom? By the adjudicating authority. Under section 7, 9, 10. Then the moratorium will apply. Moratorium means prohibited. Application against the debtor is pending, moratorium will apply. Moratorium means against the debtor, no suit can be filed. If the suit is already pending, it will not continue. When the application is pending, then the debtor, corporate debtor, will not dispose of the property, will not alienate the property, will not make the property subject to charge. And when the application is pending, because the adjudicating authority has admitted your application, and once they have admitted the application, then the security interest created in favor of the secured creditor cannot be enforced. So therefore there is a moratorium. Moratorium means ban. Moratorium means prohibited. Prohibited of what? Prohibited, you cannot transfer corporate debtor. You cannot alienate. You cannot, creditor, you cannot enforce the security interest. You cannot file the suit against the corporate debtor. So moratorium. Section 15. Let there be public announcement so that the public becomes aware that some application has been made against the principal debtor, against the corporate debtor to the adjudicating authority. Then the adjudicating authority will make the public announcement. Section 15. Public announcement giving the name and the address of the corporate debtor. The authority with which the corporate debtor is registered. Details of the interim insolvency professional. Because he is a person, insolvency professional. He is a person who manages. You have made an application to the adjudicating authority appoints the interim resolution professional. He works for 30 days and thereafter he is converted into full-fledged resolution professional. How that we'll see. So section 15, you have made an application to the adjudicating authority will make the public announcement that here is the corporate debtor, he is the name, he is the address, it is the authority with which he is registered, he is the interim corporate resolution professional, these are the details of this man, and this is the time within which he has to complete the job, date, and then you can make the claim to him and don't make the false claim, otherwise the penalty will follow. So this is the public announcement you make. Section 16, appointment. Appointment is made of the interim corporate resolution professional. Who appoints? Adjudicating authority. Whom you appoint? Because once we have made an application under section 7, 9 and 10, we have mentioned the name of the interim professional. So chunki creditor has made the application, creditor has given the name, the creditor has the stake, and therefore the adjudicating authority will appoint the interim resolution professional. Whom you appoint? Whose name has been mentioned in the application that you have made under section 7, 9, 10. They will appoint. Section 16. In case you do not want to appoint adjudicating authority. Actually, sometimes it happens. In the case of the operational creditor, he does not propose the name. If he has not proposed the name, then the adjudicating authority will refer the matter to the board. Ki kindly recommend the name. And then they will recommend, and then adjudicating authority may accept. So here you will find that the creditor has the stake, and therefore the interim resolution professional will be appointed as the creditor desires. In case you have not desired, then matter will be referred to the board will examine, board will recommend, and then he can be appointed. So this is the appointment of the... Now remember here, resolution professional can be of two types. And we have appointed the interim. Interim we have appointed. So he will act for 30 days. His term is only for 30 days. And then the resolution professional will be there. So section 16. Section 17. The corporate debtor is there. Application is made. You have appointed the interim resolution professional. Then what you will do now? You have appointed. Section 16. What he will do? He will take in charge of the management of this corporate debtor. He will manage. He will take charge. The management of the corporate debtor will rest in him. The board of directors of this corporate debtor or the partners of the corporate debtor will no longer function. He will exercise the powers. He means interim resolution professional. He will exercise the power of the board of directors. And in the case of the corporate debtor, they are the employee, they are the people, they are the manager, they will be responsible to the interim resolution professional. So therefore, under section 17, the management will go to him. He is the interim corporate resolution professional. He is there. He has been appointed. So therefore, the management will go to him. The powers will be exercised by him. All the employees of the corporate debtor will be responsible to him. They will give all the information to him. They will produce all the documents as required by him. He is a person who will execute all the documents on behalf of in the name or on behalf of the corporate debtor. He will. So section 17 is about the management. Section 18. What are the duties this interim professional? What he has to do? What are the duties? He will ascertain the position, financial position, finances, and the operational. Because when you are to manage, then you must be aware of all the situation of the corporate debtor. And therefore, the first duty is to ascertain the financial position of this man, the operation of this man. And more particularly, what this corporate debtor has done within 2 years by way of operation, what the corporate debt has done within 2 years by way of payment, he will ascertain. These are the duties. So he will ascertain the financial position. And the duty, further duty of this man, interim professional, he will constitute the committee of creditors. Because when the default is committed, the creditors are the worst sufferer. So they have to participate. So he will constitute the committee of creditors. How it will be constituted, that we'll see. He will constitute the committee of creditors. He will invite the claims from the creditors. He will monitor the assets of the corporate debtor. He will take charge of all the assets of the corporate debtor. If the assets of the corporate debtor is not in possession of the corporate debtor, he will try to take possession. If any assets of the corporate debtor is subject to determination, there is some dispute on that asset, he will take care of it. So therefore, he will take charge of all the assets of the corporate debtor. He will manage under section 17, and these are the duties that he will perform. What duties? He will take charge of all the assets of the corporate debtor. He will constitute the committee of directors, committee of creditors. He will invite the claims. He will know the financial position. That he will do. Section 18. Section 19. When he is there to take charge of the corporate debtor, then the personnel of the corporate debtor and the promoters will help him, will provide all the information wanted by him. If they do not assist him, he can make an application to the adjudicating authority, okay, please look here, they are not assisting me. Then the adjudicating authority may direct, okay, please comply his direction. This is section 19. Coming to section 20, which is very important. Now, when this professional, interim resolution professional, is carrying on the business, now remember here, he will carry on the business as a going concern. Because you are here to improve the situation. So he will manage the affairs as a going concern. He will make every possible effort to protect and preserve the assets of the corporate debtor. He will make effort to preserve and protect the assets. He will carry on the business of the corporate debtor as a going concern. He will give directions to the people of the corporate debtor. Okay, please carry on the business in a way as a going concern. And whatever step necessary for this, he will take as a going concern. And for going concern, if he wants to appoint accountant, he can appoint. If he wants to appoint any professional, legal professional, he can appoint. If as a going concern he wants that some contract should be modified, he has the right. So as a going concern. Section 20. Section 21. Committee of creditor will be constituted. interim resolution professional will constitute the committee of creditors. Now remember here, the creditors can be of two types. There can be financial creditor, there can be operational creditor. The committee of creditors will be only of the financial creditors. So therefore, the interim resolution professional will constitute the committee of creditors, and the committee of creditors will be only of the financial creditors. Only of financial creditors. If suppose some particular debt is due to two financial creditors, then both the financial creditor will become the member of the committee of creditors. If suppose you are a financial creditor as well as operational creditor, then to the extent of the financial creditor, you will be on the committee of directors, committee of creditors. So therefore, constitute the committee of creditors under section 21. Now coming to section 22. What the committee of creditors will do? Now you have constituted the committee of creditors. Creditors, financial creditors. Committees created. Because they have the stake, therefore they must have the say in the whole process. So committee of creditors, what they will do? They will make the recommendation. They will appoint a resolution professional. They have the two options. Either you can say that because after all, he is the only interim. Therefore, you have the two options, committee of directors, committee of creditors. You have the two options. One is, you can say that the interim resolution professional will be the resolution professional. You can say. You can opt. Committee of creditors. Or you can appoint other person as the resolution professional. If you appoint the same person who is the interim resolution professional as the resolution professional, then kindly inform him. Kindly inform the debtor, corporate debtor, and kindly inform the adjudicating authority. If you do not opt for him, you opt for another person as the corporate resolution professional. You propose, you recommend the name that he will be the corporate resolution professional. Then the adjudicating authority will forward your name. If you have said that this person should be the resolution professional, interim should be the resolution professional, then there is no problem. Because the creditor recommended this name and therefore he was the interim resolution, and you say, committee of creditors say that this will be the full-fledged resolution professional, there is no difficulty. But in case you say that no, interim resolution professional will not be resolution professional, some other person will be there, then you recommend the name to the adjudicating authority for the appointment. Appointment will always be made by the adjudicating authority. Then adjudicating authority will forward your recommendation, your name to the board for confirmation. And he confirms, then the adjudicating authority will appoint him as the resolution professional. Suppose he does not confirm, 10 days he has to confirm, he does not confirm, then the adjudicating authority will say, all right, interim will continue to function. So therefore under section 16, interim will be appointed. Interim performs certain functions, section 17, 18, 20, 19. 21 committee of creditors, section 22, then the resolution professional is appointed. Then once the resolution professional is a different man, is appointed, then the resolution professional will take charge of the situation. And if the resolution professional is different from the interim, then the interim resolution professional will send all the document to him. under section 23. Then meeting of the creditors. Under section 21 you have constituted the committee, and section 24 you are holding the meeting of the creditors. Creditor will play very important role in the whole process because they have the stake. If the situation of the principal of corporate debtor improves, they are to gain, and therefore they will take care of it. So therefore, friends, the meeting is held. Meeting of the creditors, committee of creditors. Either it will be held in person or it will be held by electronic means. In the law, we have not provided how many meetings will be there. And then when the meeting is to be held, then the notice will be given. Notice will be given to the creditors who are the members of the committee, to the suspended board of directors, and to the operational creditor as well. Though operational creditor is not a member of the committee of creditor, but the notice will be given. Notice will be given to them. So these people may attend the meeting. Operational creditor may attend the meeting, his representative may attend the meeting, or suspended board of director may attend the meeting, though they will not have the right to vote. Right of vote is only to the members of the committee of creditors. Now remember here, even if I do not make the mention of it, take a note of it. The creditors, committee of creditors will decide by 3/4 of majority. Anything which comes before them, and they will have to take a decision, they will take a decision of 3/4 majority. Now how the 3/4 majority will be calculated? On the basis of the value of the creditors. Take an example. Suppose they are the 5 creditors. They are the members of the committee of creditors. They are the 5 financial creditors of the principal debtor, of the corporate debtor. They are the 5 financial debtors. 5. To one, he owes 100 rupees. To second, yes, so there is a debtor, and there is the financial creditor. He owes 100 to him, A. There are the 5 means A, B, C, D, E. A, B, C, D, E. He owes 100 rupees to him, he owes 200 to him, he owes 300, he owes 500, he owes 400 and 500. 1, 2, 3, 4 and 5. So total amount that he owes to 5, 4, 9, 312, 214 and 115. 1500 he owes to 5 creditors. Correct? This is the value. And then they will decide by 3/4 of value. 3/4 means, suppose let us say 600. So 100, 200, 300, 400 and 600. He owes 600 to him. So 1600. So the creditors who have the value of 1200 or more than 1200, they will decide. It can be 600, 400 and 300. 1200. So he owes to 5 creditors, financial creditors, 600 rupees, correct, and they will decide by 3/4 of majority value. So therefore, you constitute the committee of creditors under section 21, you hold the meeting under section 24. Correct. So 21 you constitute the committee, 22 you appoint the resolution professional, 23 the resolution professional will perform its function, and 24 you hold the meeting. Then we pass on to 27. Actually, as you know, in the case of the board of directors, shareholder have the right to remove the director. Similarly here, the committee of creditors may remove any resolution professional. This is given in section 27. At any stage, committee of creditors can say that we wish to replace him by another person recommended by us. They can. And then they can say to the adjudicating authority, we are replacing and therefore you appoint him. Adjudicating authority, before appointing him, will report the matter to the board for confirmation. If the board gives the confirmation, you may appoint. If the board delays the confirmation, does not give the confirmation, then the adjudicating authority may say कि जो अभी तक काम कर रहा था, the person who has been acting as the resolution professional under section 22 will continue. So you have the power to remove. Or you have the power to replace. We have not used the word remover. We have said replace. Section 28. Certain functions of the resolution, certain acts of the resolution professional will be subject to the approval by the committee of creditors. Will be subject to the committee of creditors. What are those acts which will be subject to the committee of creditors? Professional resolution want to change the management of the corporate debtor. You can do it with the prior approval of the committee of creditors. Change the management. Change in the terms of the personnel of the corporate debtor with the prior approval. Change in terms of the auditor, terms of the appointment auditor, take the prior approval. So therefore he is the corporate resolution professional. He has to do certain acts, take the prior approval of the committee of creditors. What? You want to change the management of the corporate debtor, take the prior approval. You want to change the terms of the employment of the statutory auditor, take the prior approval. You want to change the terms of the employment of the people in the corporate debtor, take the permission. You want to change the capital structure of the corporate debtor, take the prior approval. You want to delegate your power, take the prior approval. You want to deal with the related party to the corporate debtor, take the prior approval of the committee of creditors. You want to change. So therefore, for these acts, take the prior approval. What are those acts? Change the management, change the terms and condition auditor, change the terms and condition of the personnel of the corporate debtor, delegate the power, deal with the related party of the corporate debtor, take the prior permission. If corporate debtor has the financial institution which they deal and the committee of creditors have fixed some limit, or up to say you want to increase the limit, take the prior approval. You want to increase the interim finance, take the prior approval. Interim finance means what? I will let you know. So for these acts, you have to take the prior approval. And for taking the prior approval, call their meeting, committee of creditors. And they will give the approval by 3/4 of majority, that we have already seen. If without the approval you take these acts, this will be void. This is section 28. Now let us stop for a while. Let us stop for a while. So therefore, let us summarize what we have talked about until section 28. They are the two authorities. They are the interim resolution professional. He is appointed under section 16. He manages. He has certain duties. He has to see as a going concern. And other personnel of the corporate debtor will help him. These are his. Section 16, 17, 18, 19, 20. This is one part. Then there is a committee of creditors. Section 21 we constitute, and section 24 we hold the meeting. This is. Section 22 we appoint the resolution professional. 22. He will conduct the operation thereafter. He will conduct the operation thereafter. And then the committee of creditors, you constitute the committee of creditors, you hold the meeting, and then under section 27, the committee of creditors can replace the resolution professional. So section 16 to 20, section 21, 24 and 27, committee of creditors. 22, he appoint the resolution professional. 23, he performs. He conduct the operation thereafter. This. And resolution professional, certain acts are subject to approval by committee of creditors. So these are the authorities. And the most important thing is, this is one part. Second part is, whether it's a case of the resolution, interim resolution professional, adjudicating authority appoints. It's a case of full-fledged resolution professional, adjudicating authority will appoint. But adjudicating authority does not have much discretion. If you have made the application under section 7, 9 or 10 and you have recommended some name, then the adjudicating authority will appoint him. Appointment will be done by the adjudicating authority. If you have recommended, he will appoint. If you have recommended, he will appoint. You have given the name, he will appoint. If you have not given the name, he will ask for the board to make the recommendation. So there are two things. Now where the board comes in the picture. The adjudicating authority role. What is the role of the adjudicating authority? You make an application to him. Application is admitted by the adjudicating authority if satisfied. That's the commencement, and the adjudicating authority will appoint interim or the full-fledged, whatever that may be. That we have seen. So this is the role of the adjudicating authority. What's the role of the board? Role of the board is to help the adjudicating authority. You have not made the proposal for the interim resolution professional, then the board will ask him, kindly recommend the name. Recommend the name. Recommend the name. And if you have replaced the name under section 27, then adjudicating authority will ask the board, kindly confirm this. And once he confirms board, then you appoint. So appointment is always done by the adjudicating authority. Now friends, in section 5, now we can see certain definition. Definition of the initiation of the corporate insolvency resolution. Initiation, what do you mean by initiation? Initiation means when you make an application under section 7, 9 or 10. This is the initiation. What is the commencement under section 5? What is the commencement? When the adjudicating authority accepts your application. That's the commencement of the resolution professional. What is period? Resolution professional period. It is 180 days. 180 days. What's the dispute? Dispute. Why the dispute is important? Because under section 8 we have seen that the operational creditor, before making an application, will give you the notice, demand notice. And the operational debtor may say, okay, we have a dispute. I have not made the payment because I have a dispute. So what is the dispute? Dispute means suit or arbitration proceedings in relation to the payment of debt, in relation to the goods supplied or the services rendered. This is the dispute. Then what is the financial debt? Section 5 also talks about. Financial debt means you borrow, you raise money by the issue of bonds, you create the liability by creating the charge. That is the financial debt. So an operational debt, any amount which is due by way of delivering of the goods, that is the financial debt. So that is the operational debt. Then related party. Related party is important. Why? Because under section 28 you are to deal with the related party of the corporate debtor, then take the prior permission of the committee of creditors. Then who is the related party? You are the principal debtor, you are the corporate debtor. Who is the related party of yours? He is the corporate debtor. Who is the related party? He is the corporate debtor. A. Who is the related party to him? Number 1, maybe the director, maybe the partner. Number 2, who is the key managerial personnel of the corporate debtor? He is the related party. Number 3, partnership or the limited liability partnership, where the director or the manager of the corporate debtor is a partner. Related party means you are connected with the corporate debtor. How you are connected? Either you are the corporate debtor, either you can be the director or you can be the partner. Correct? Or if you are this partnership or limited liability partnership can be the related party if the managing director or the manager of the corporate debtor is the partner. This is the private company. This private company can be a related party to the corporate debtor. If in the private company, the managing director, the manager, he has the stake in this, or he is the director in this private company, or the public company can be related if the manager of this is the director of the public company. Any body corporate can be related party if the board of directors of the body corporate, they are accustomed to act as per the direction of the manager of the corporate debtor. So these are the related party. So these are the definition. So section 1, extent to all of India. Section 2, applicability of this code, apply to everybody. Resolution and the liquidation, resolution and the bankruptcy of everybody. Whether you are individual, it applies. Whether you are the firm, this act applies. Whether you are the limited partnership, this act applies. Whether you are the corporate house, this act applies. In regard to what? Either resolution, insolvency or liquidation of the bankruptcy. This act applies. But we are dealing now only in regard to corporate house. So this is section 2, section 4. Okay, now chapter 2 starts. Chapter 4 starts. Section 3, chapter 1. Chapter 2 starts. So chapter 2 applies to the corporate house. and where the debtor has committed the default. So this all up to section 28. Now, so you have managed the affairs. Now then, you have managed the affair, what for? What's the purpose of managing? You are in difficulty, they have managed. You have appointed and they have managed. Then ultimately, what's the purpose of this? Resolution plan. Then there is some resolution applicant. He prepared the resolution plan under section 29. Correct. Under section 30, resolution plan is submitted to the, because actually what happens, there is a person who prepared the resolution plan, and resolution professional has furnished all the information to him. He prepared the resolution plan and he submit the resolution plan under section 30 to the resolution professional. Resolution plan covers many things. After the approval of the resolution plan, how the management will be done, whether the resolution plan is in contravention of the law, you have to ensure. So he submits the resolution plan to the resolution professional and he sees the resolution plan. He looks at it. First he sees that all these things are complied in the resolution plan. The resolution plan does not contravene any law. Resolution plan talks about the management after the approval. Resolution plan, who will supervise the resolution plan? He sees all these things. After seeing this, he will send this resolution plan to the committee of creditors for their approval by 3/4 of majority. And once they approve, then under section 31, he will submit the resolution plan to the adjudicating authority for approval. And if the adjudicating authority is satisfied that everything is fine, then the adjudicating authority will approve the resolution plan. You have been engaged in the resolution of the insolvency and this is the plan, I approve, it is binding. Once you approve, it is binding on the members, on the creditors of the corporate debtor, on everybody, on the guarantors, on the employees. So section 30, you submit the resolution plan to the corporate resolution professional who prepares resolution. He is known as the resolution applicant. He prepares, he submits. And then he looks at the resolution plan, section 30, section 30, and then he submits to the committee of creditors. They approve, then he submits under section 31 to the adjudicating authority. Adjudicating authority approves, it's binding. But suppose the adjudicating authority has decided and somebody feels aggrieved, he can go in appeal under section 32. Appeal to whom? National Company Law Appellate Tribunal. Now then, section 33, winding up. What is winding up? Actually, in 180 days, the adjudicating authority did not receive the plan. Or adjudicating authority rejected the resolution plan. Then the adjudicating authority will order for the winding up of the corporate debtor. Will order of the winding up, liquidation, and will make the public announcement. And will ensure that the order of the adjudicating authority is filed with the respective authority. So under section 33, if in 180 days resolution plan is not prepared, or if prepared but rejected by the adjudicating authority, then the adjudicating authority will order for the winding up of the corporate house. So you want to improve, if you have improved then the plan, if you have not, Then the winding up. Finish. Then the liquidator is appointed. Under section 34, resolution professional will become the liquidator. Under section 34. Then the liquidator does the things. Hopeless situation, winding up. We wanted to avoid, but we could not avoid, then the winding up. As in the case of the patient, what is happening? What happens? Patient is in bad shape, doctor tries to revive, doctor tries to cure him. Keeps on trying. When he fails, suppose the patient is in critical condition, you want to revive him so that he survives. You cure him, doctor. Make all possible effort. You fail, then you ask the family to kindly take him to home. Let him pass the time. This is what exactly we do. They are the doctors, here the doctor is resolution professional. So winding up. Then the liquidator is appointed. He does his job. Finish. Whatever he does his job, he does his job. Then lastly, section 52 and 53. Now what about the secured creditor? The security interest has been created in favor of the secured creditor. He has two options. Security interest has been created in his favor. Then the secured creditor may leave the security interest and may say, all right, company is in winding up, you kindly make the payment. I am not taking out of the security interest. You kindly make me the payment. Or he has the security interest, he can realize his security. So secured creditor, two options. Either he can leave his claim to the security, or he can say, all right, kindly make the payment, or he can realize, he can enforce the security interest under section 52. If suppose the secured creditor enforces his security interest, he will inform the adjudicating authority. He will inform, I want to enforce it. And this is the security over this property. He will identify the property. And then the adjudicating authority or the authority will verify his claim or will say, all right, realize. Now then, this is section 52. Section 53. Now, how the assets are distributed. Liquidator has realized the assets. There ought to be some priority in the payment, because remember, he is in bad shape. He does not have the full asset to make the payment of all liability. Therefore, some order of priority. Now, actually, when you initiate the resolution professional, then the cost is involved. What the resolution process cost? What the resolution professional cost? Resolution professional cost. The cost of the liquidator, the fee of the liquidator, and the charges incurred in carrying on the business. They are known as the insolvency resolution professional cost. Cost. So therefore, when the liquidator has to distribute the assets, first priority is process cost. resolution process cost. Insolvency resolution process cost. First priority. Then he will distribute the amount equally. If something is left, he will distribute the amount equally. The workmen whose wages are due for 24 months. In between, today, suppose January 2018, and then in 2 months, 24 months mein workmen dues, and then the secured creditor, they will bear equally. So first is the cost, second they will bear equally. Then the fourth is other workmen dues, not in this, or other dues. Fifth is unsecured creditors. 6 and 7 will bear equally. Government dues, and if any amount is left unrealized, because the security, the creditors has enforced the security interest. Suppose by enforce the security interest, he only received 90%, 10% is not received by him. So you will just 10%. So what is that due? Number one, cost, which include the fee of the resolution professional. Secondly, equally, 24 months, and then secured creditors, equally too. Then third, yes, other dues to the workman, other than this, 24 months, workman dues, and unsecured creditors. Then unsecured creditor, then equally to the government dues and 10%, and then other dues, and then equity, preference shareholders, then equity shareholder. This is how the amount will be distributed. So friends, this is the entire act. Now here, let me summarize. So actually we are not concerned with the entire act, entire code, which has 255. We have only part 1, preliminary, and definitions are given in section 3 and section 5. And some of the definition I have already dealt with. And section 7 onwards, 28. This is one part. Section 29, revival plan. 30, 31, 32, revival plan. It does not work, then the winding up. Section 33, 34, liquidity appointed. And then 52, 53, 54, finish. Now friends, this is the entire act. Now, so professional is a very important person, adjudicating authority is very important, and the board is important. These are the authorities. Information utility, they have the centralized information of all the debtors. These are the authorities, and this act applies to everybody. We first to solve the problem, we can't solve, then bankruptcy or the liquidation. Now the question is, what is the difference between insolvency and bankruptcy? Insolvency and bankruptcy, they are one and the same thing. You are unable to pay debts, and therefore we are to handle the insolvency. If we do not handle the insolvency, it may result, in the case of the company, winding up, in the case of the partnership firm, in the bankruptcy, or in the individual case, bankruptcy. Finish.